Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. So far in talk, we've spent most of our time answering one question: is the defendant liable? We've looked at duty of care, breach, causation, damage, and even defences. But today we finally reach the question your client probably cares about the most. If I win, what do I get? This episode is all about damages. More specifically, what losses can the claimant recover after a successful claim? The good news is that this topic is much less complicated than many students think. In reality, most of it comes down to identifying which losses belong in which category. So let's get started. The purpose of damages is our starting point, and it's a very simple principle. The purpose of damages is to put the claimant in the position they would have been if the wrong had never happened. Think about a damaged bicycle. If a defendant destroyed your bicycle through negligence, the basic aim is simple. The defendant should pay you enough money to allow you to repair or replace it. Personal injury is harder. Money cannot reverse a broken leg. Money cannot remove chronic pain. Money cannot restore someone's life exactly as it was before the accident. Instead, damages act as financial compensation for what has been lost. That idea sits at the centre of the whole topic. Now let's look at the first big distinction. And for SQE purposes, the most important distinction is between non-pecuniary losses and pecuniary losses. Non-pecuniary losses are things that cannot be measured precisely in money. Pecuniary losses are financial losses that can be calculated accurately. If you remember that distinction, the rest of this particular video becomes much easier. So non-pecuniary losses are where we're going to start, and there are two big categories. The first one is pain and suffering. This compensates the claimant for the pain and suffering caused by the injury. It includes physical pain, emotional suffering, distress, fear of future treatment, ongoing symptoms. The key point is that the claimant must actually be aware of the suffering. If somebody is unconscious, they cannot recover damages for pain and suffering during that period because they're not aware of it. The second category is loss of amenity, and this compensates the claimant for losing the ability to enjoy aspects of their life. Examples include loss of mobility, inability to participate in hobbies, loss of independence, inability to play sport, diminished enjoyment of everyday activities. Now, this head of loss is often worth more than students realise. A keen runner who can never run again has lost something significant. A musician who can no longer perform has suffered a serious loss of amenity. Unlike pain and suffering, awareness is not essential. The focus is what has been lost, not what the claimant can consciously appreciate. So how are non-pecuniary losses valued? Students often ask, how does a court put a price on a broken leg? And the honest answer is, there is no perfect way. So lawyers and judges use previous cases and published guidance to identify appropriate ranges for particular injuries. The aim is consistency, not mathematical precision. So if you see an SQE question asking about pain, suffering, or loss of immunity, focus on identifying the head of loss rather than calculating exact figures. Pecuniary losses. So as we've said already, these are the losses that can be calculated financially, and these are often much easier to understand. The question is, what has this injury cost the claimant financially? So the first category tends to be medical losses, and the claimant can recover reasonable medical expenses arising from the injury, and this could include treatment costs, rehabilitation, physiotherapy, specialist equipment, travel costs related to treatment. If the expense is reasonably connected to the injury, it is potentially recoverable. The second category is lost earnings, and this is one of the most important heads of damage. If an injury prevents the claimant from working, they can recover lost income, and there are two separate periods. Past losses, so these are earnings already lost before the trial. These are genuinely straightforward to calculate. The court looks at what the claimant would have earned and compares it to what they've actually received. Take one from the other and you have your past losses. Future loss is much harder. The court is effectively trying to predict the future. Questions include: how long would the claimant have continued working for? What would they have earned? Can they return to work? Will they need a different career? And the precise calculations here are always going to be complicated. For SQE purposes, you simply need to understand that the court estimates future losses and awards compensation now. Third type of cost is care and assistance. Some injuries create a need for help from others. This may involve nursing care, domestic assistance, gardening, shopping, personal care. The claimant can recover the cost of that care. Importantly, this applies even if the assistance is provided by family members rather than professional carers, and the law recognises that the need for care itself is a loss caused by the injury. There are other financial losses that can be reasonably recovered. Examples include damaged clothing, damaged personal property, additional travel costs, specialist equipment, home adaptations. And the guiding question is, would this loss have arisen if the accident had never happened? If the answer is no, there is a good chance it forms part of the claim. Then we now move on to look at the duty to mitigate. And this is an important limitation. The claimant cannot sit back and allow losses to grow unnecessarily. They must take reasonable steps to reduce their losses, and this is known as mitigation. For example, they have to look for alternative employment. They have to seek appropriate treatment. They have to replace essential equipment. The defendant is responsible for losses caused by the tort, not the losses the claimant could reasonably have avoided. Now, another principle students need to know is the one action rule. The claimant gets one opportunity to recover damages. The court awards compensation for past losses, present losses, and expected future losses. The claimant cannot usually come back years later asking for more money because events develop differently than expected. This is why future losses are so important at trial. The court must estimate them in advance. Now, what happens then if the claimant dies? Now, the key thing to remember is that two different types of claim can arise where we have a fatality, and students often confuse them. Claim number one is what's known as the estate's claim. So the first claim belongs to the deceased person's estate. Think of this as, what claim did the deceased have before they died? The estate can continue that claim. So it may include pain and suffering before death, lost earnings before death, medical expenses, property damage. Any damages that are recovered become part of the deceased's estate, and they are then distributed under the will or intestacy rules. Claim number two is actually something that belongs to dependents. So the claim exists because the death may have deprived relatives of financial support. The law therefore allows qualifying dependents to recover for lost financial support, lost services, and lost care. And this is a completely separate idea from recovering the deceased person's own losses. The focus here is what the dependents have lost. There is also a specific statutory bereavement award. This is not compensation for financial loss. It is a fixed sum payable only to certain qualifying categories of claimant. Students do not need to memorize detailed calculations. The key point is simply recognizing that such an award exists and that eligibility is restricted. Finally, funeral expenses may also be recoverable. The exact route depends on who paid them. But for SQE purposes, remember that reasonable funeral costs can form part of the recovery following death. So what's Bowdie's bottom line? Well, remedies become much simpler if you ask one question. What has the claimant actually lost? For a living claimant, that usually means non-pecuniary losses, so that's pain and suffering and loss of the community, and pecuniary losses, which are lost earnings, medical expenses, care costs, and other financial losses. If the claimant has died, think separately about claims for the estate, so what losses did the deceased suffer before death, and claims for dependents, what financial support have dependents lost. And then also consider bereavement awards. Is there a qualifying claimant entitled to the statutory award? If you can identify those categories, you can navigate most SQE questions on damages without getting lost in the mathematics. Thanks as always for watching this Bowdie Shorts.